Morning, Your Honors.
Good morning.
My first time back in person since the COVID days.
Well, welcome.
John Maher from the Montgomery County Bar. I represent Christopher Gary Wallace, the appellant in this case. I'd like to reserve 5 minutes.
5 minutes for rebuttal. Very good.
Thank you, Your Honors. I'll start out with addressing the abuse of discretion on the continuance of the trial. It was an extended time, and the appellant had been through several attorneys. The issue here was his latest attorney. The case was set for trial. The attorney came on board within a few days of getting the case, filed a motion to continue, looking at it and knowing that it was going to be too complex, in her opinion, and I did not try the case, in her opinion, to move forward with the case with the ability that she had.
But counsel, was it enough just to file the motion? I mean, one of the points made by the appellees here is, well, it wasn't set either, and if you just file the motion and wait for the day of trial to plead for continuance, doesn't that indicate some dilatoriness in pursuing your request for continuance?
Well, it was set. It was set before the trial. It was set before the trial, and the court denied it. And so then they tried it the next week. So it was set before. And I don't have an explanation of the court's docket at that time and why, after it was filed, that was the date it was heard on. But it was heard before the trial, and it was denied. And I think it was denied mostly on the basis that the appellant hadn't been compliant with the court's rulings prior, and so she was not willing to grant any additional times.
Counsel, why is that an abuse of discretion? I mean, there's an extensive time period to obtain counsel. Counsel wasn't obtained during the time period, wasn't obtained until close proximity to trial. You have Mr. Wallace is less than cooperative with the trial court in terms of the orders that have been issued. Why is it an abuse of discretion to decide under those circumstances to not continue the case?
Well, the only thing that I would say in regard to that is because counsel was on, because the complexity of the issues that explained to the court on the motion to continue, that, you know, in that situation when you know you've got somebody that's pro se that's had difficulty dealing with the court to begin with, and counsel does come in after an extended period of representing himself pro se, that it's probably in the best interest, just in the best interest of justice, to continue it, to make sure that it's properly prepared for trial.
One of the things I gathered from your brief is because your client tested drug positive during the course of the trial, that should have been another indication that the judge should have stopped the proceedings right there. Is that one of your arguments on the continuance here, or is that just sort of a side note that you were making?
I guess that's the second part of the argument for the continuance. And my question was, and of course I wasn't the trial lawyer, but why would the judge go through this, appear or perceive that he was unable to testify appropriately and recall things appropriately, and say, I want a drug test done, which is very unusual in a civil court to order someone to go take a drug test, and then comes back and says, yes, there are drugs in your system. You know, no clear indication that he was, you know, if he was intoxicated at that point or not, or under the influence of drugs, but it was in the system. Why did the judge go through all those procedures to have that testing done and then just say, okay, let's continue?
Well, didn't the trial judge here give Mr. Wallace an opportunity to potentially have things delayed, and that he wanted to proceed?
That was not my perception of what happened, and not his perception, that she just went forward.
So are you suggesting then that your client couldn't validly give his consent to proceed at that stage, or because of his being under the influence of a drug?
I think it more dovetails into his post-trial motions, where certain things the court, the appellee mentions that, hey, you didn't mention all this stuff at trial. You didn't bring all this stuff clearly forward at trial. And the judge, knowing this situation at the time and not granting continuance and not stopping the proceedings then and reset it for another day, then he came back with his motion saying, specifically with regard to the vehicles, all these vehicles were clearly titled in my name before the marriage. But the appellee's position is, hey, we put it in our brief as marital property, and our list of marital property, the court accepted that list as marital property, and therefore it's properly divided, and the fact that they weren't actually marital property doesn't matter. And I guess that kind of dovetails into our point that the court on review of that, clearly this is not divisible property. There's no doubt that these vehicles were purchased before the marriage. Here's the titles. I think it dovetails into that the court should have given more consideration to that when it came back.
I almost suggest that after the fact you're saying, well, husband here should just get a do-over because not properly presenting their case at trial, though.
Well, and I think my argument to that, Your Honor, is it's not a do-over because the appellee in this case represented that this was marital property. Said this is marital property, and it was not marital property, and she knew it was not marital property. She knew the vehicles were purchased before, but she represented to the court, and the court accepted those representations that those were marital property. So that was one of the issues with the vehicles. And I think the
Counsel, this seems like a different circumstance, though, than, let's say, somebody has a health issue that arises during the trial, and somebody's having some sort of illness that impacts their ability to testify, to concentrate. And should we really treat someone walking into a courtroom who may be under the influence or is under the influence of drugs the same way we'd treat a medical issue in terms of a continuance?
I guess the effect is the same on the individual, whether it's an illness or it's from use of drugs, because a lot of people unfortunately use drugs these days, and they'll have some consequences from that. But I think the overlying thing was that then learning that that these are clearly not marital property was the issue, and the representations by the appellee that they were. I think the court then could have come back based on all those factors and said that, okay, these are clearly not marital property, and the court should.
But that evidence wasn't presented at trial, was it?
It was not, Your Honor. The only evidence presented at trial was the appellee said they were marital property, but they weren't. So that's a misrepresentation, and she knew it. She knew they weren't marital property. She knew they were purchased before the marriage. So that was our point in that. And then the bigger issues involved the real property, really, and the way the court handled that real property, and that was really a big issue. The court really didn't state what was separate property and what was marital property. The court never made a decision, never made a finding with regard to that. So we don't know if she classified properties as marital or separate. So there's two properties involved. There's the homestead, which the evidence was uncontroverted that home was owned by my client prior to the marriage, completed, finished, and owned by my client, and everyone agreed that he spent $547,000 building that house before the marriage. The court didn't identify whether it said it was transmuted into marital property, didn't say it was separate property, didn't say whether she was applying a standard that established that during the marriage there were significant contributions and therefore she should get a portion of the appreciation of the house. None of those factors were addressed. She simply said, I'm going to give you the 2004 assessment for the value of the property, $37,000 when it was gifted to him by his father, and I'm going to give the $100,000 you put in the house that you sold before to build this house, which was all done before the marriage. And so the court didn't do any findings, and we invited the court to make findings of fact and conclusions in law in our post-trial motions, asking the court, tell us whether you identify this as marital or separate property, whether you're talking about its transmutation, whether you're talking about if you're saying that the appreciation in the property, the value of the property, is what the court is going on. But it didn't rule on any of those. And when we did our motion, again, the court made no rulings on those whatsoever. So we don't know what the court found. But the facts are it was clearly before the marriage that he built his home, $547,000. Appellee agreed to that was what he spent on it. That's what my client had owned in the property. And then there's the second piece of property. It was bought during the marriage, but that's not dispositive, because the money used to purchase that second property, titled in my client's name only, not in the appellee's name, just in my client's name, the money used to purchase that was a loan
Counsel, isn't there a dispute, though, about that in terms of, doesn't Ms. Wallace instead counter that this is actually a gift that was given to both of them? The check was made in both of their names rather than just Mr. Wallace's name?
At the trial of this matter, she did not. There was uncontroverted testimony that it was $80,000 to my client.
So there's no trial testimony saying
There's no trial testimony. Now, at the motion to alter amend, then she did say something along that line, but she didn't say it at the trial. But she said it at the motion to alter amendment. So there's no evidence at the trial that that was not existent. And she admits that this was a loan, a home equity loan on the other piece of property that was used to purchase it. So based on those two standards, those are monies that are clearly traceable to either a gift during the marriage, which doesn't transmute it. It's titled in his name only, and the other money used to purchase the home is from the separate property that he owned before the marriage. So
All right.
those are our issues on that.
All right, thank you, Mr. Mayor. You'll have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
Jacob Mathis for the appellee from the Montgomery County Bar. I'll start with addressing the continuance, and I'll try to take these issues in the order that they were presented by counsel. I believe the trial court was well within its discretion to deny the motion to continue. If you look at the record, counsel for the appellant originally withdrew on November 1st of 2021. This trial was held on April the 4th of 2022. It was 5+ months after the date that counsel withdrew. During that time, the appellant was under temporary orders to make support payments for the benefit of his wife and child. He didn't do any of that. The record is riddled with the important behavior of the appellant, wherein he refused to follow the orders of the court time and time again throughout these proceedings. And then, having hired counsel about a month before a trial that was really going to be a fairly simple divorce, in my opinion. We're going to divide two pieces of real property. We're going to set some support. We're going to divide some personality. That's about it. There weren't a lot of issues as it related to the business in terms of proof for the court. Fairly simple, typical divorce situation. Counsel's hired a month before trial, says that's not enough time to get ready. We think it's well within the trial court's discretion to say that that is, in fact, ample time to prepare for this hearing and to go ahead and proceed as scheduled, given the totality of the circumstances in this case. And again, appellant's refusal to follow the temporary orders of the court, which was severely prejudicing Ms. Wallace. You know, the proof at trial was she had incurred substantial amount of credit card expenses just staying afloat throughout the pendency of this case because Mr. Wallace was not doing the things the court told him to do. And we get to trial, and one of counsel's questions this morning was, why did the court see fit to have Mr. Wallace drug tested in the midst of a hearing, which admittedly is somewhat atypical? Well, Mr. Wallace denied being under the influence of narcotics on the stand. Are you under the influence of any drugs or alcohol today? And he said no. The court just didn't believe him. So during the break said, you go downstairs and get a drug test. And it turns out that he had in fact lied under oath to the court and was at least under the influence to the extent that those drugs were still in his system because he tested positive for them. And at that point, even though granting a continuance would in essence give Mr. Wallace what he wanted based on bad behavior, which is not precedent I think the court wants to set, but even at that point, the judge asked counsel specifically, given the circumstances, do you want to proceed? And counsel said yes. I mean, I think the court gave them the opportunity that it could and should have under the circumstances, and they elected to move forward regardless. So I think the basis that the court somehow abused its discretion by continuing forward at that point was waived at the trial level when counsel said, we want to press on, knowing that Mr. Wallace had tested positive for methamphetamine. With regard to the division of vehicles, we presented a Rule 1006 summary with a list of assets and valuations of those assets, all of which were owned during the marriage. If Mr. Wallace had asserted at trial that any of those vehicles were in fact separate property, we were prepared to present evidence and cross-examine him as to the fact that these vehicles were used for the business throughout the marriage. Maintenance was done on these vehicles. Marital funds were used toward the benefit of these assets. We were going to question him about those things, but he simply never disputed our assertion that those were items of marital property. And as we know, title does not dictate classification. Something that's originally separate property can obviously be transmuted into marital property through the conduct of the parties. And we were prepared to present evidence of that as it related to the vehicles, but Mr. Wallace simply never refuted our assertion that it was marital property, so that wasn't necessary. The court found our summary to be appropriate and made its division of those assets based on our list of valuations. And another thing to point out is that Mr. Wallace never presented the court with any valuation of just about anything, at least not in a coherent manner that would make sense to a trier of fact. And that moves us right into the real property. There are two pieces of real property that were divided in this case. What I'll call the 41A property, which is just the street that the property sat on.
And that's the location of the business?
Correct, Your Honor. Yes, that is where the business was located. And the business, as Mr. Wallace admitted, was tremendously impacted following the party's separation because, based on his testimony, his wife did a lot as it relates to the contracts and to the office work of this business. And it is a lawn care business, but it's a lawn care business that was grossing in excess of $400,000 a year. So, excuse me, a somewhat substantial business that, after the party separated at the time of trial, Mr. Wallace alleged was making $500 a month. So his wife's absence all but destroyed his business based on his own testimony.
Counsel, is the trial court's order in this case adequate to let us understand the basis of her ruling in terms of how she's valuing these properties, who's getting what, and not necessarily clearly identifying what's marital, what's separate, and why? And do we have an order that's sufficient to allow us to review here?
I think so, Your Honor. I think it's, and I guess the Trough Springs Road house is probably the more contentious piece of property. And to answer your question, I think she implicitly says it was marital to an extent with a separate contribution by ordering it to be sold and dividing the proceeds in the way that she did. She very clearly set out what she felt were the separate property components to the total valuation of the property. She did not provide a value for the house, but I don't think she was required to do that under the circumstances because she was ordering it to be sold. So it was going to bring whatever it was going to bring, but she did specifically say, well, there's proof that Mr. Wallace was gifted the lot that was worth $37,000 at the time. No evidence presented to the court that there was any contrary valuation. So the $37,000 value of the lot is what she used. And there was evidence that he had put $120,000 from the sale of a prior residence into the property. So he was given that full $157,000 as separate equity in a piece of property that, while originally purchased as separate property, had been transmuted based on the conduct of the parties. It was clear at trial that Ms. Wallace had been involved in the building of the property, the design of the property. All of the payments were made for the during the marriage, and this was a 10-plus year marriage.
And they cohabitated prior to the marriage, is that correct?
Yes, Your Honor.
So how long a period of time was that?
As I understand it, Mr. Wallace never spent one day in that house that Ms. Wallace didn't live there with him.
Okay.
And I think that's a good question, Judge, and it's noteworthy. All of the money comes from the business. So to assert that Ms. Wallace didn't somehow make a substantive contribution to the property seems a bit of a fallacy when you look at the fact that after they separated, the business almost ceased to exist. This once prosperous lawn care company that was making $20,000 a month is now making $500 a month. So if all the money came from that business that she contributed to, then that's marital funds that were making almost all of the payments toward that piece of property. And the court implicitly found that it had been transmuted into marital property based on the way that it divided the proceeds from
Was the lawn care business a sole proprietorship, or was it a separate corporate?
It was, yes,
okay.
sir. And I think going back to the 41A property, it was purchased during the marriage, and yes, it was purchased with a HELOC loan on the Trough Springs Road house, but all the payments toward that HELOC loan were again made from the proceeds of the business that each of the parties contributed to. So to somehow say that it simply because the loan is tied to a piece of property that I originally owned separately makes this new piece of property separate doesn't feel like an argument this court should accept. The court doesn't have any other questions for me. I'll just rely on the written materials.
All right. Thank you, Mr. Mathis.
Thank you all.
Mr. Mayor, we'll hear for your rebuttal.
Your Honor, I think the focus here is implicitly. Everything we determined from that order has got to come from somehow divining what the court did and decided. The court's responsibility is to identify the property first of all, whether it's separate and whether it's marital. And then once it does that, if it's going to try to do something, transmutation, it's got to give what are the factors that you use to determine that it was transmuted to marital property. None of that's laid out. If the court is going to say, I think the value at the time of marriage was $137,000, when the clear testimony was that $537,000 was spent on the property prior to the marriage to build it and construct it, and it was completed before the parties were married, then the court needs to identify what it is they're saying is the equity in the property beyond that point, and whether or not that equity should be divided between the parties. The testimony at trial was that some payments, the sole testimony of any contribution to the house was that some payments were made on the house. That's all she said. That's the sole piece of testimony that indicates anything with regard to after these parties got married, what was done with the house. And it was that some payments were made on the house. The payments were made on the house, which obviously they were. The payments were kept up during the marriage. There's no question about that. The question is that alone enough to then transmute it to marital property? Well, that would be almost every marriage, right? There would be hardly any separate property if you got married, and as soon as you got married and you were making payments on a mortgage on your house, it just automatically, as a matter of law, became marital property. And that's not the state of the law. And the fact that it's just not identified at all in the order how she came to these decisions or what she even classified it as. In my brief, I had to brief if this is, what are the factors for transmutation, and then I said, well, if the court didn't say it's marital property, then if we go to the valuation of the property and what the increase in value was, then we look at those factors. And the only factor that the judge identified was that she contributed as a household, contributed to the household as a homemaker. And that was in her conclusions, but it was never once testified. There was no evidence put on. There was nothing in the transcript indicating that. For the court to then make that decision, I'm assuming that, again, the court just implicitly found that she must have been a homemaker, and that was the factor it used. But there's no evidence to support it. So I think that's the key issue here is, the appellate courts and the court's demand under Rule 52 that we put in there the law and the facts that we rely upon. And you got to start out by identifying. And the fact that they were, there's no common law marriage in Tennessee, so the fact they were living together didn't establish any right to her in that property. The property was completed, built, my client sold his former property, took out the loans in his name, built this house. There was no guarantee they were going to get married because they were living together, but they eventually did get married after the house was built. So that, again, was clearly his separate property at the time of the marriage, because she couldn't gain any interest in it other than through a quitclaim deed, or if she had some kind of, if they argued there was some kind of constructive trust because it was all her money that went to build the house or something of that nature. But none of that existed. So it was separate property to begin with. So I don't think the court could jump to that conclusion that it's marital property without some serious findings of fact and statement that I find that it was separate property, but I find it was transmuted. I find that it was separate property and maintained his separate property, and that I find that the equity in the property should be divided equally. And what is that equity based on? Is it based on improvements? There's no testimony of improvements. There's just testimony of payments on the mortgage. There's no testimony of improvements, the increase in value, and the court stated this, the increase in value simply due to market forces is not something that's divisible. You have to go farther than that. You have to show substantial contribution to the maintenance of that property. And there's just none of that here. She didn't testify she made any payments out of her own earnings. She didn't testify that she made any payments herself. They're just simply the mortgage payments. And simply making the mortgage payments doesn't get us to from separate to marital property. Thank you, Your Honor.
Thank you. The case is submitted. We thank counsel for both sides. All right, if you call the